Okay, I think we're going to get started now. Welcome, everyone. My name is Fred Larson. I'm the president of the National Institute of Social Sciences. And today we are delighted to have the second in our series of three webinars surrounding the 2024 election. What's at stake? Expert perspectives on the 24 election. Today, we are delighted to have a couple of excellent speakers who can talk about the issue body politics, legal issues in the 2024 election cycle. Let me start off with some webinar logistics. You are all on mute by default. Only the panelists and moderator will speak during the session. If we do ask you to speak for any reason, we will be able to unmute your microphone. The chat is also disabled, so please submit any questions via the Q&A function, and we'll make sure that the panelists get them. Finally, the link forum is being recorded, and we'll share the link after the event, so you can watch any or all of this session again or share it with your colleagues in the future. We are the National Institute of Social Sciences sponsoring this event. We are a congressionally chartered not-for-profit association of public-spirited citizens who seek to understand and improve our world through the study and discussion of vital social issues. You can learn a lot more about us at our website, www.socialsciencesinstitute.org. Okay, let's get started. Today with us, we have Anthea Butler, moderator from University of Pennsylvania, who's running the moderation duties for the entire webinar, and Tobias Wolff from the University of Pennsylvania as well, although from the Carey Law School. What I'd like to do now is turn it over to Anthea and let her run with it.
Thank you so much, Fred. Thanks for having us this evening. Thanks for all of you who are here. It is my absolute pleasure to introduce to you Tobias Wolff, who is the Jefferson B. Fordham Professor of Law at the University of Pennsylvania's Carey Law School. He writes and teaches in the fields in civil procedure and complex litigation, conflict of law, constitutional law, and LGBT rights. He is the co-author of Civil Procedure, Theory and Practice, and recent articles include Class Action, Statutes of Limitations and Repose, and Federal Common Law, Choice of Law and Jurisdictional Policy in the Federal Courts, Scott v. Harry and the Future of Summary Judgment, and a bunch of others that I am sure we'll probably end up getting into tonight because he has a very storied resume. His JD is from Yale in 1997, and I personally just want to say that he has been one of my greater colleagues at Penn, and it's a real pleasure to have him to talk about some of the things that he knows so well and some of the things that intersect my work, weirdly enough. So thank you, Tobias, for being here with us tonight.
Thank you very much for including me in this great series. And I will just say that Anthea Butler is one of the main reasons that I love the University of Pennsylvania and being a member of the scholarly community there. And, you know, in addition to all of the scholarly work that I do on civil procedure and complex litigation, which is about lawsuits and court systems and how all of those work, which I think we will touch on in various ways. A lot of what I do also relates to constitutional law, public policy that touches on people's lives outside the context of courts and litigation. I do a lot of LGBT rights work, and maybe pertinent to our conversation, I'll just mention when President Obama was running for office for the first time in 2007, 2008, which is a while ago now, but still, I served as the chief advisor to his campaign on LGBT law and policy and wound up playing, I guess, a pretty significant role as an outside sort of trusted advisor to his White House during the time that he was in office. And I will also mention, I have known Kamala Harris for 20 years now. And I want to be clear whenever I mention this, I hate it when people overclaim their sort of connection to important people. I'm not on her speed dial or anything like that, but I met her in well, you know, we'll see. But I met her in San Francisco when she had recently been elected at that point as district attorney, and knew that she was a person of greatness and destined for great things. And in fact, told people at the time, and I have receipts that I can produce if anybody doubts me, that she is going to be the president of the United States at some point. And I have followed her career and supported her campaigns through her movement from district attorney to attorney general of California to senator from California. I actually advised her campaign and her a very little bit when she ran for president in 2020, and am thrilled that she is our nominee and have great hopes that she will be the next president of the United States. And of course, the question, which is part of why we're here,
Yeah.
of who prevails in this election, has very direct implications for a lot of issues that bear on how people lead their lives on a day-to-day basis, and individual liberties and equal treatment and citizenship status for
Yes.
people of all different kinds throughout the United States. And so I think we're going to spend a chunk of our time talking about that today. And Anthea, why don't you tell me where we should start with that huge sort of massive issues?
Yeah, it is a huge set of massive issues. And I want to start with reproductive rights. And I want to start off by reminding you of a story that I know I won't have to remind you of, but because it crosses my home state. I've been thinking a lot lately about Wendy Davis. And because of the filibuster and what happened in Texas as the precursor to of Dobbs and all of this stuff. And in my work, we always talk about, Roe versus Wade, that was always going to be there. And now it's not. And this is based on, basically what has been said in this campaign a lot about states' rights. And so wanted you to start a little bit by talking about this very big issue to say, how should people understand this in terms of two ways? One is the erosion of this big issue of abortion, first of all. And then secondarily, how it is being deployed in the campaign. And I think you and I can do a little bit of back and forth on that.
So the first thing I'll say is to put in context the gravity from a historical and institutional perspective of the Supreme Court destroying the well-established constitutional right to access to abortion. Because we talk about Roe versus Wade as our shorthand, right? As the case that, of course, established that right.
Mhm.
But that risks under describing the institutional position that Roe versus Wade occupied, or that the right of access to abortion occupied in
Mhm.
our constitutional doctrine. Because, you know, Roe versus Wade produced both a lot of judicial disagreement in the years following. Roe itself was a 7-2 decision, right? With a majority of the justices who voted in favor of the outcome in Roe were Republican appointed justices. And indeed, if you do the math and look over the scope of decades, a majority of justices who have voted for decades to uphold the right of access to abortion have been Republican appointed justices, which helps put in context a little bit just how radical the current Supreme Court is. But more than that, because it was a very actively contested issue, because it's become a political football and source of strife for many years, there were a lot of efforts to overrule Roe. And those efforts, what you might think of as the first major phase of those efforts, culminated in a decision in the Supreme Court in 1992 called Casey versus Planned Parenthood of Southeastern Pennsylvania. And Casey was a decision that reaffirmed the right of access to an abortion, the constitutional right of access to an abortion. It reaffirmed it in a somewhat qualified way, and we can get into this if you all want to, but Casey safeguarded a right of access to abortion, but subject to greater restrictions and regulations than had been permitted previously. But it nonetheless upheld the core of that right. And in so doing, the court also issued a ruling on precedent and on how the Supreme Court should think about overruling its own precedents, and gave what remains today the most substantial and weighty and consequential description and explanation of the principles that ought to guide the Supreme Court when it is asked to overrule one of its earlier precedents. And so Casey was a reaffirmation of Roe, of the core of the rights in Roe. But it was also this statement about the precedential quality of Roe as a decision that there was not a good faith case to be made that there was a reason for the Supreme Court to revisit its earlier decision, right? That's like a major part of the holding of Casey.
Right.
And so following Casey and the greater level of restriction that it made possible, right? It upheld the right of access to abortion, but it made it possible for states and the federal government to regulate it a little bit more aggressively. We then saw this era of what were often described as trap laws, right? Targeted regulations on abortion providers. And these were laws that both regulated abortion just as a kind of general regulatory matter and said things like you can't get an abortion after the point of viability. If you want to get an abortion, you have to first go to a provider, and then there's a waiting period and you have to come back. And we can talk a lot about the class impacts of that on people who have, wage-based jobs and can't just be going to clinics multiple times for a simple procedure. But then hostile states got even more creative, and they started passing laws that were direct regulations on providers, on abortion providers, that purported to be health and safety regulations, right? But that were about driving providers out of business and making it impossible for providers to keep on offering abortion to their patients. And so they would require that abortion providers that doctors at abortion organizations that provide access to abortion have visiting privileges at hospitals within a certain distance.
Right.
And there's no clinical need for that to be the case. And in fact, this is not my area, but getting visiting privileges is a whole thing. Like, it's not just a sort of box that you check. It's a whole professional relationship that doesn't just happen automatically, and resulted in lots of doctors not being able to continue providing abortions in states that had these targeted regulations. They would do things like, and I'm not making this up, they would regulate the width of the hallways that you needed to have in buildings where organizations that provide access to abortion were located. And these purported to be descriptions of, well, if there's an emergency and somebody has to be on a gurney, you need to make sure that the gurney can do a complete 360-degree turn in the hallway just in case that's necessary and getting them out. Like, it's ridiculous. And these had nothing to do with actual safety, but they were attempts to drive, and very successful in many instances, attempts to drive abortion providers out of business, and culminated in a decision of the Supreme Court in 2015. I need to make sure I'm right about that, but I think it's 2015, called Whole Women's Health versus Hellerstedt.
Yeah.
And this is a Texas case in which several of these laws, admitting privileges laws, and some of these kind of building code style laws were challenged. And in a very important and sort of resounding holding, the Supreme Court affirmed its earlier decision in Casey and said, yes, we did say that certain kinds of regulations are permissible, but fundamentally we reaffirmed the right of access to abortion, and we meant it. And we didn't mean that you could use the window in Casey to just drive abortion providers out of business. And they gave a strong and robust account of the right, the continued vitality of the right of access to abortion, and struck down some of these targeted regulations. And that was the state of affairs when Donald Trump was elected to the presidency in 2016, and then got to start replacing justices. And, there's an intervening decision involving some Louisiana restrictions that were very similar to the Texas restrictions, identical in many ways. And the court kind of waffled on whether it was going to apply its precedent in the Hellerstedt case. And then the personnel shifted further, right? Justice Gorsuch and Justice Barrett were appointed. And then we got the Dobbs decision in 2022. It's hard to believe it was only 2 years ago. It feels like, an era has already passed.
Yeah.
And so there's a lot to talk about, obviously, in the consequences of Dobbs to women and girls and anyone else who becomes pregnant, to people needing to access healthcare, to healthcare providers, to educational institutions. I mean, the multi-level impact of this decision, we're still only beginning to understand. But from an institutional perspective, if you think about the Supreme Court as an institution,
Mhm.
the overruling of the right of access to abortion was not just the overruling of Roe versus Wade. It was the overruling of this case, Casey, which was the single most important description in the Supreme Court's history of how precedent should operate and
Yeah.
why Roe should not be subject to these sort of politically driven efforts to take rights away from people simply because personnel on the Supreme Court has changed. And an overruling of this case, Hellerstedt, which was a powerful reaffirmation of that right in the face of 25 years of efforts to use these targeted regulations to accomplish kind of, indirectly what you couldn't accomplish directly. And so it was stunning. And the last thing I'll say, I'm sorry, this is going on for a long time
No.
here, but the last thing I'll say is that, and we can get into this more if you'd like to, the Dobbs decision itself, Justice Alito's decision for the court, just analytically, just as a matter of judicial reasoning, is just an embarrassment. I mean, it
Yeah.
is, given the consequential quality of what the court was doing, it is just a very thinly and unconvincingly reasoned decision, and its treatment in particular of history, which it purports to be grounding itself on, is an embarrassment and erases, among many other things, but I'll mention just one, erases the long history of monetized forced pregnancy in the United States that was the systematic institution of slavery and enslavement, and the role of the 13th, 14th, and 15th Amendments in disestablishing all of the practices associated with enslavement in the United States, including monetizing the bodies of Black women and taking their ability to control their pregnancies away from them. And and this was presented to the court in their briefing, and they treat it as though it doesn't exist. It is an embarrassment of a decision, and yet here we are forced to live with its aftermath.
Yeah, and thank you. That's really helpful because I thought that that would be a good way to set this up. But I think what's really important to say is to just always remember that they basically, wiped away precedent from other courts. So it's basically it's like we're smarter than those people were. We didn't have to do this, and we're going to do it our way. So that's really important for where I kind of want to go to bring us to now with the kind of problems we're dealing with. And one thing I had asked you to talk about was the court just denied President Biden's appeal on emergency abortion care in Texas. And so I wanted to just kind of hear from you about what does this mean for women? You talked about what this means for women who can't just go off and do everything. And what we've been seeing here in the last couple of years since 22,
Right.
especially with the election, the midterms in 22, and then now in 24, is that, abortion is on the ballot. We keep hearing this over and over again. But this is also putting a lot of women in peril because basically you can't get care, and all of this has been pushed on top of my favorite phrase that I really hate, states' rights. And so I was wondering if you could just kind of unpack all of that for us, and we can kind of do a little bit back and forth about what this sort of means now, because there's a lot going on and we can't hit it all, but I want to definitely talk about what just happened this week, and then about Florida and this ban to not wanting to have women talk about the kinds of repercussions of what happens.
Yeah, absolutely. So let me start with, I'll get into the sort of legal and constitutional stuff in a second, but I'll just start with a basic proposition, which is that abortion is healthcare,
Yeah.
and access to abortion is access to healthcare. And it may be the case that our audience finds that to be an entirely unremarkable proposition. This is a sort of furiously, like, rage-filled, contested proposition in political and social and media discourses and disputes about abortion. You do not have to look very hard to find people, mostly men, although not all men, I must say, from either elected officials or from conservative advocacy organizations or conservative think tanks or whatever, getting platformed at CNN and major media outlets and saying just with absolute conviction, abortion is not healthcare. That's ridiculous. Abortion is not healthcare, right? And I want to be very clear. Abortion is healthcare where the condition that it addresses is a person who is pregnant who doesn't want to be. And we have focused a lot of attention for very good reason on the medical consequences and the medical emergencies and the fatal consequences sometimes of people not having proper access to abortion when they need it in the context of a medical emergency. And I think there are both human reasons for doing that. I think there are, these are some of the most acute and urgent and pressing situations that arise in the wake of Dobbs. And there are also political reasons for doing it. I think that those cases are striking and they have a very powerful impact, and not everybody understands that overruling the right of access to abortion has these emergency medical consequences. I just always feel the need to also at the same time emphasize that when a woman discovers that she is pregnant and decides that she does not want to be, that is a sufficient medical reason for her to have access to an abortion. And I think that the terminology of healthcare of access to abortion as healthcare should not be reserved for situations that we all sort of recognize as emergency medical situations.
Yes.
So I just want to sort of say that. Okay. So with that precursor, what happened in Texas and the Biden administration's appeal being denied is a case about what we would colloquially understand as emergency medical situations. So there's a federal statute called EMTALA, which is the Emergency Medical Treatment and Labor Assistance, I think, Act. And it is about hospitals and emergency rooms. And it requires that if you show up at an emergency room with a medical emergency, you have to be treated. You can't be turned away. If the hospital is receiving federal funds, I think is how the statute is structured. And following the decision in Dobbs, the Biden administration the Health and Human Services Department issued some follow-up guidance that said, just to clarify, we think that this is already very well established, but since it's now even more important to be clear about these things, if somebody is having a medical emergency and they're pregnant, and the care that they need in order to address the medical emergency is an abortion, then EMTALA requires that hospitals and emergency rooms provide that care, provide an abortion. And if state law purports to make that illegal, this federal statute preempts state law, right? This overrides state law. And so this is important because part of what we have seen in states, particularly, kind of most insidiously, in states that purport to preserve some kind of exception to their bans on abortion for emergencies where a woman's life is in danger, right?
Yeah.
And Texas is one of these states. These states interpret their statutes, and indeed the Texas Supreme Court has interpreted its statute to either directly require that the woman is in such dire emergency that she will imminently die or imminently be going into major systems failure, organ failure, before that qualifies, right, for providing access to an abortion. Or, and this is part of what the Supreme Court of Texas did, they refused to provide clarity on this question. So that, I hate to have to use this term, but it's the reality that we all live with. Risk managers in hospitals, whose job it is to make sure that hospitals don't lose their accreditation and that doctors don't go to jail and that hospitals don't get sued for millions and millions of dollars. They wind up advising their practitioners that you effectively have to wait until this, imminent death or imminent organ failure situation, because we can't provide confidence otherwise that we're not going to be criminally prosecuted and sued by providing this medical care. And so, when people talk about this issue, they'll often raise these exceptions, and the Republican nominee for the presidency often, he never knows what he's actually talking about in terms of policy, but he'll often wave his hands and say, exceptions are great, exceptions are great. You have to have exceptions. the on-the-ground reality is that unless they are defined in a way that allows healthcare providers to make the decision about when a woman's health is severely, severely at risk, and they don't have to worry that after the fact, somebody else is going to come in, second guess their decision, and they might be subject to losing their license or being prosecuted or being sued. Unless you have that ability of healthcare providers to be the ones who decide when a woman needs healthcare when she presents with an emergency, then these, exceptions on the books wind up having very little impact at all.
Yeah.
And so, I'm sorry, go ahead.
No, no, no. I was going to say, the classic case here is last month in ProPublica, the case of Amber Nicole Thomas, who died in Georgia because of this. There's a great ProPublica piece, and I'll put that in the chat when we get down to the questions about, how long do you wait? And then when you wait too late, right? And this is the problem.
Yep.
This is the fundamental issue. So I think, what I would do before we wrap up this section is just to ask you, in terms of thinking about this for this election cycle, what should people think about in terms of, most everybody here who's going to listen to this, maybe some people won't be. Most everybody is in New York State right now, right? And I'm in Pennsylvania, and I will probably pass this on to some of our friends down in southern states. What are the big markers for this particular issue should we think about before we move on to the next big piece that we're going to talk about?
Sure. So let me say a couple of things. The first is just to very quickly wrap up this whole EMTALA,
Yeah.
like emergency medical care conversation. The fight right now is whether that federal statute, number one, ever requires that healthcare providers offer an abortion at all.
Okay.
And the argument of conservative activists and the argument that the Fifth Circuit Court of Appeals accepted in this case that the Supreme Court refused to review on an expedited basis is that because this federal statute EMTALA doesn't, in the words of the statute, say, you have to provide emergency medical care, including abortions. It doesn't say including abortions. In essence, the Fifth Circuit said, well, it doesn't say including abortions, and therefore we think the statute is, there's no clear guidance from the statute about requiring abortions. And this is a huge conversation, and I'll just mention it, and we can't go into it deeply. Part of what's been going on for some years now is a massive assault at the Supreme Court on the administrative state in the United States. That is to say, on the ability of the federal government to interpret and apply federal statutes in a way that responds to emerging needs and emerging situations. And the Fifth Circuit decision essentially goes, sort of around the bend in saying, if the statute doesn't say states have to, or hospitals have to provide abortion in these emergency situations, and state law to the contrary notwithstanding, then the statute doesn't mean that, and HHS can't provide regulations that say, well, obviously, like, it doesn't say you have to provide any particular kind of care, right? It doesn't say anything. It just says you have to provide the appropriate standard of medical care. And so a huge part of what is going on in the emergency medical treatment setting is wrapped up with conversations that you might hear about the administrative state and the Supreme Court taking away the ability of administrations like the Biden administration or any administration, but it's really focused on more center-left policies right now, their ability to respond to emerging needs, right? So that's like one thing to understand. And here's the other thing, and I'll try to do this quickly, but it's super, super important. So the conversation that we often have about what would happen if Trump and JD Vance get elected is, well, they would support the enactment of a federal law, which would be a national ban on abortion.
Right.
And, JD Vance has said very clearly that he supports this, and Trump has certainly indicated that in various ways over the years. And, neither one of them, I don't know what either one of them actually believes. Certainly Trump doesn't actually believe anything other than whatever serves his personal interests. But their response to that in this election is to try to muddy the waters and say, no, and we wouldn't do that. And well, we'll have to take a look, and, you leave it to the states, and that's good enough, right? So all of that is a bunch of BS for the following reason. There is already a pair of federal statutes on the books from the late 19th and early 20th centuries. There's a statute called the Comstock Act from 1875. And then there's a follow-up statute that amended and expanded the Comstock Act that was enacted in like 1909 or something like that. And these federal statutes prohibit any transportation across state lines of, or in the US Postal Service, even within a state, of any device or material that is used in providing an abortion.
Right.
And so it is already the case that there is a federal statute on the books which would constitute a national ban on access to abortion. And up until 2.5 years ago, nobody even looked at this statute as a serious thing to worry about because it was obviously unconstitutional under Roe and Casey and Whole Women's Health, right?
Yeah.
But unconstitutional doesn't mean that it was struck off the federal statute books. It just means that it couldn't be enforced. Following Dobbs, the question then arose, well, what happens if we get an administration that decides to get religion on the Comstock Act and start enforcing it? And there's all kinds of reasons why that federal statute might still be unconstitutional. It was not primarily focused on abortion. It was primarily focused on sort of broad morality regulations, and it regulates sexually explicit material, which I think means like, you know, books that present women as having agency. And
Yeah, or whatever.
you know, believe me. And so like there are very serious constitutional challenges one can make to these statutes. But when you hear people who are trying to respond to the issue of access to abortion, when you hear them say, well, you know, we're not really interested in enacting a national ban. Number one, don't believe them, in my view. But number two, that's a deflection, because if Mr. Trump and Mr. Vance get into office, they don't need to enact a new federal statute in order on day one to start enforcing this pair of statutes that are already on the books and shutting down access to abortion and abortion-related health care for everybody in the country with no exceptions. These statutes have no exceptions. They have no time limitations. They have no nothing. They are just categorical criminal bans. And the only thing that would stop a Trump-Vance administration from enforcing those statutes is their choice about whether or not to do it. And then we would have to challenge their constitutionality. And while I believe very strongly that those statutes, for other reasons, are unconstitutional, there is no guarantee that the Supreme Court would agree. And so what's at stake in this election is not just that every single state in the South, with the exception of Virginia, is now a forced pregnancy state where women cannot get access, women and girls and everybody else cannot get access to abortion, even in many circumstances in cases of medical emergency. But what is also at stake is that there are these, you know, loaded weapons of statutes waiting to be pulled out of their holsters and turned on the entire American public. And the only thing that would stop that from happening is the good graces of Donald J. Trump and J.D. Vance. And I don't think you can place a lot of stock in that.
No, you can't. And thank you for saying that, because Comstock is really important, because part of what the conversation has been, you know, among women's groups has been about, you know, this is not just about abortion, but it may even be about, you know, birth control, right? You know, suppose you get your birth control through Amazon pharmacy, right? That might not happen anymore. And so I think people really need to understand how deep this goes. It's not what's one thing, but a whole complex of things that could just completely fall apart. And thank you for that really thorough explanation.
And by the way, on that really important point on contraception, two very quick things. One, part of what you see among what I would characterize as extremists, or at least, you know, aggressive advocates on the issue of women's reproductive rights, is the assertion that lots of commonly used forms of contraception, including the pill, are abortifacients.
Yes.
And this is just medically untrue, right? This is just either a willful lie or a complete misunderstanding of how a woman's reproductive system operates, right? But they claim that these contraceptives are abortifacients. And that is a very deliberate effort to wrap an ability to regulate those directly under the Dobbs decision, right? And I mean, this predates Dobbs, but they're trying to weave it all together. And the other thing is that there's a separate a pair of Supreme Court decisions that guarantee a fundamental right of access to contraception. But those decisions are part of the same family of decisions that gave us Roe versus Wade and Casey and Hellerstedt. And while the Supreme Court didn't say anything one way or the other about whether those cases were next, Clarence Thomas has made very clear that he has those cases in his sights, along with marriage equality and many other rights that people have taken for granted for, I mean, contraception for a long time, marriage equality for a shorter time. And I don't know what the Supreme Court would do if they were asked to overrule a right of access to contraception. I don't know.
Yeah, and I think that's something we should all be really thinking about through this cycle, because it's like one thing fell, but like it's dominoes, right? Once one goes, there's all these other things, and there's other ways for them to, take down things that we have taken for granted, basically, access. The next thing I want to talk about is twofold. One is trans issues and the anti-trans ads in 2024 election, but to wrap this up in gender transition care, because this has been a really big thing. And I want to preface this for everybody by linking this to something that I do, which is to talk about religion in the family. And this has been a very big issue about, we don't want kids to have access to care. I grew up next to literally 15 miles away from the first hospital that did transition care in Galveston, Texas. And so I've known about this for a long time. And I think that one of the things that I'm hoping that people understand is that all of this has been under assault, and part of it has been under assault because of our university, remember, and our, the person on the swim team who this ended up becoming a big stink about. And so I was hoping you could talk about that in relationship to these ideas about sexuality right now that are also coming forth in the 2024 election cycle, that I think people may not understand, but really need to understand as part of not just the right to identify how you want to identify, but also how that is going to be taken away from you
Yeah.
if
Yeah.
with this, if certain things happen.
It's a huge and hugely important issue. And right now, the principal focus is on young people, right? On people under the age of 18, under the age of majority. And I would characterize the assault on access to gender transition related care, gender affirmation care for young people as a strategic decision on the part of advocates to go after what they think will be the most sort of vulnerable chink in this edifice, and that if they can succeed in banning access to this care for young people, then they're going to start going after banning access to that care for adults as well. And there are a few places where they've started doing that. And gosh, I mean, there's so much to discuss here. So one, let me start by saying the following. I think it is very important that any provision of medical care that can sometimes include surgical interventions or sometimes include medical interventions that have side effects or that have consequences that are not easily reversible, right? It has to be administered according to a responsible standard of care. And a responsible standard of care, both that relates to the safety and efficacy of the treatments, and also the protocols by which you decide who's going to gain access to that treatment and how they're going to be administered, right? And every responsible person whom I know who does work in this field, whether they are medical care providers or whether they are public policy people or whether they're lawyers who litigate these cases, agrees with that. And insofar as there are any examples, and I think the claims of these examples are vastly overstated, right? But insofar as there are any examples within the United States of clinics or healthcare providers providing access to this type of care without following appropriately rigorous protocols, I think that's a situation that should be addressed, just like it would be if medical care were being provided in an irresponsible fashion for any other person under any other circumstance, right? But that's not what these laws are about. These laws that we see getting enacted in state after state after state are not about ensuring responsible provision of this care and responsible protocols. They're about categorically prohibiting access to this care for young people.
Yeah.
And a lot of the overwhelming consensus among experts, among researchers, among practitioners in the United States, and more broadly, who actually have studied the question of gender dysphoria or gender affirmation related care. There is a very powerful consensus that, administered according to an appropriate set of protocols, there are young people and adults who need this care, who benefit greatly from this care, whose lives are massively impacted in a positive way from gaining access to this care, and whose lives are massively impacted in a negative way if they're not able to gain access to this care. And there are lots of debates going on about, how robust is the scientific evidence and how rigorous is it and all of that. And we can talk about that a little bit if you like. It's not my area of expertise, but I can offer a couple observations about it. But fundamentally, the experts who actually spend their lives working on this issue have a very, very powerful consensus that this is safe and effective care and important and often necessary for the well-being of the patients who are seeking access to it. And the efforts to ban this care are often really just supported by kind of laughably weak junk science. I mean, one of the things that you see is that, and I'm going to be clear, there are some reputable studies that have called into question some of the protocols by which this care is provided to young people. And I don't want to dismiss that. I want to take that seriously. But in these lawsuits, in the lawsuits challenging these categorical bans on access to care for young people, they bring the same experts to every single lawsuit often. And they're people who have never provided this care themselves, who don't actually do research in this area. They're just people with a degree in something that's vaguely medical and an opinion, basically. And the first sort of round of litigation challenging these laws was remarkably successful on the part of civil rights lawyers at the federal trial court level, district court level, which is where a judge has to actually sit and hear evidence. And these judges, regardless of whether they were Republican or Democratic appointed judges, they know weak evidence when they see it, right? And they, one after another, they ruled in favor of the people challenging these terrible laws because the science that the states were relying on was just terrible science.
Yeah.
But that turned when these cases started going up in front of appellate courts, and federal appeals courts have started issuing pretty bad decisions that, at least from my perspective, bad decisions that both give a lot more credit to the states in their ability to, sort of deference to the states in their ability to rely on the experts they want to, even if, by objective standards, the experts are piss poor. But also, they've issued some pretty bad rulings on how we should think about laws that target trans people as a legal and constitutional matter. And they've started issuing decisions that say these laws that are explicitly targeting gender affirming care, that are explicitly about denying access for care to trans people, are not anti-trans and are not discrimination, and so shouldn't be understood as discrimination. And even if they are, that kind of discrimination is not a big deal. And those are terrible, right? And so that's where the fight is right now. And the Supreme Court has taken a case called Scarametti, which is going to hear this term, in which presumably they will decide some of these issues. And so there's a sort of high stakes case in front of the Supreme Court. In parallel with all of that, you see political strategists, including the people who are running the ads for the Trump campaign, apparently deciding that this is their issue and running these really just ugly and vicious and factually inaccurate ads about trans people and trans kids. And, I mean, Trump, it's just all pardon me for, it just all becomes so exasperating to have to talk about this. But, you know, he in the debate and in some of his rallies, he goes on about how, you know, kids go to school one day and they have an operation and they come, I mean, just completely unhinged assertions that have nothing to do with reality. But he just says these things and people don't know, right? Like his audience, most of them have never investigated the question of what these protocols are, and they're giving their trust to him, and he is betraying that trust by giving them terrible information. And they have decided that this is their issue. And I don't know, and I would love to hear your view on this. I don't know whether it's going to be politically successful at anything other than motivating his base. But what I do know is that it's creating an atmosphere of just relentless menace and threat and danger for trans young people that is just terrible.
Yeah, I would say this. I think it's a motivation for their base, but it also pulls in stragglers. And what I mean by stragglers is that people who may not have this on their radar screen, but start to believe the conspiracy theories. In other words, they believe that, oh, they're doing this at school. And I mean, like, no, this is a process. It goes on for years. It's not like something you do overnight. But the fact that they think that kids are somehow being pushed into this is how groups like Moms for Liberty and others are really pushing this. And so that's why I wanted you to say something about this, because I think it's really important this election cycle, because it is definitely a wedge issue. And then finally, the last thing that I want to touch on before we let people ask questions is you kind of mentioned it at the very beginning, but I want to get to the space where we might see this week. There were some remarks about maybe interracial marriage shouldn't happen anymore. And I kind of previewed that to everybody when I saw folks on Monday. And then about marriage equality. I think these two issues of marriage are, you know, basically at risk maybe with this court. And I thought maybe you could tell us just a little bit about that before we go to some Q&A.
You bet. So I will just start by saying I don't think that Loving versus Virginia and the constitutional prohibition on anti-miscegenation laws, the proposition that the state can't tell you who you can and can't marry based on their race, right?
Right.
And of course, specifically, the state can't enact white supremacist laws, which the
Right.
laws in Virginia explicitly were. I don't think that those principles are in any danger of going away. And I will explain briefly why people have expressed that concern,
Mhm.
but that concern I don't share.
Okay.
So the marriage equality decision, the Obergefell decision for same-sex couples, was decided in 2015, and which is so remarkable, just 7 years ago, right? Like it just feels, once again, like, you
A
know,
long time ago,
worked
right?
on, exactly, like I worked on this issue for many years as a lawyer and as a scholar and as a public policy advocate. And, you know, there's endless, not endless, but there's a bunch of videos of me, old videos on YouTube debating this issue with various, you know, advocates and people. And then we got Obergefell and we thought, my God, like this huge chapter, like it's done. And, but it's a recent decision. And to go back to our conversation about contraceptives and access to contraceptives, the same line of doctrine that the Supreme Court called into question when it overruled a right of access to abortion in the Dobbs decision, that is the same line of doctrine that largely underpins the so-called fundamental right to marry, and which was the primary basis, arguably the sole basis for the court's decision in Obergefell about marriage equality. And so we now have a serious conversation, and I'm very worried about this, about, you know, if a state decides to generate a test case by enforcing whatever anti-marriage equality laws are still on their books, and they get sued, and they can argue that Obergefell should be overturned, and that the overruling of Roe versus Wade also calls into question marriage equality. And once again, Clarence Thomas said this very explicitly when he was writing his separate opinion in the Dobbs case. And I should mention, I don't want to go on too long about this, but Clarence Thomas has been very successful at being an idea driver on the court. And he, you know, for some years he was thought of as a little bit of a an iconoclast who, you know, would write his separate opinions, and people would think, oh, there goes Clarence Thomas again, but nobody would think that much of it. And some of his, what were thought of as really out there opinions, have been adopted by the full court now that the full court is as radical as it has become. And so now people are thinking, well, you know, Clarence Thomas has driven forward some other ideas, and now he's driving forward this one. So if Obergefell is in danger, and I'm worried about it, the marriage equality decision, why would people think that Loving and interracial marriage might also be in danger? So Loving was the decision. It was in 1967, and it was the decision in which the Supreme Court first identified and gave voice to this idea of a fundamental right to marry. And Loving is basically a two-part decision. And part one is about equality and equal protection, and part two is about the fundamental right to marry. And so it's an interesting fact. There's actually a long conversation to be had about this, that nowadays, and for a while, people think about Loving really almost exclusively in terms of the fundamental right to marry that it recognized, right? And so when people started looking at the Dobbs decision and what its implications are for marriage equality and Obergefell, and he said, well, wow, if the fundamental right to marry is suddenly also in doubt, then does that mean that Loving is in doubt? And the thing is, the fundamental right to marry half of, it's not, the fundamental right to marry section of Loving is almost a toss-off. It's like two short paragraphs right at the end of the decision. It took this sort of, you know, took on this outsized importance, but it's this very short part of the opinion. What Loving is almost entirely about in the first section of the opinion, which is 95% probably of the opinion, is the equality, the equal protection principle that you cannot have white supremacist laws. And Loving is actually the single most powerful and explicit statement of not just some kind of neutrality, equal protection idea, right? Like colorblind equal protection idea. There's nothing colorblind about Loving at all. Loving is explicitly about white supremacist laws. I mean, it uses that language, and how white supremacist laws are unconstitutional under the principles of the 13th, 14th, and 15th Amendments and have no place in our jurisprudence. And it's a very interesting fact that people have kind of like put that, the dominant explanation of the court's holding in Loving, into a kind of historical like memory hole of some kind, because we don't want to talk about white supremacist laws being unconstitutional. That's not how discourse in front of the Supreme Court usually goes these days. But that's what Loving was about. And in order to overrule a right of access to interracial marriage, what the court would have to do is not just get rid of the fundamental right to marry, but get rid of the entire equal protection holding of Loving and say, you know, pages of explanation about white supremacist laws are not any longer how we're going to interpret the equal protection clause. And there's just no reason for the court to do that. And they can do everything they want to the fundamental right to marry without touching the equality part of Loving. And I just don't see, I mean, you're not going to hear me say a lot of nice things about where the court is right now, but I don't see there being a constituency on the court beyond maybe Justice Thomas for disestablishing that principle under the Equal Protection Clause.
Okay, great. Thank you. I want to open it up for some questions, Fred, if you have any. There might be one down here in the chat already that I didn't see. So we have a few minutes for those. And thank you, Tobias.
Oh, sure.
There is. So let me ask a question first, if I may.
Sure.
You've made fairly comprehensive, Tobias, you know, some of the threats that many of these issues that we've been talking about, these rights that people believed were in fact settled, are now under attack and or being rolled back. One issue, as you said, that clearly the one slate of candidates in this election either is for continuing this rollback or is preferring not to say, but if they're elected, they could in fact enact that, or they could allow their people to enact that by existing methodologies and so forth. So I would make one assertion is one way to stop that is to not elect that candidate
Sure.
and his vice president. However, what you're talking about seems to be a very long lasting, multi pronged attack from a number of different directions. How do you think this gets rolled back? Does it get rolled back? Are we fighting, a losing battle on the barricades and, for the moral cause, but, are we overwhelmed?
Yeah. Yeah. So I think there are two. Let us imagine a world in which Vice President Harris is elected president, and in which Democrats retain control of the Senate and regain control of the House. Let's just start with that proposition, just for purposes of discussion. At that point, Democrats in Congress in particular are going to have a big decision to make about the role of the filibuster in the processes of the Senate. And the filibuster has in some ways a moderating effect on the types of legislation that comes out of the federal government. And that can be good because federal legislation is powerful and can sweep away important local and state policies. And the traditional description of the role of the Senate is to serve as a kind of moderating force in Congress. However, historically, the filibuster has been powerfully associated with very socially regressive goals and was the primary barrier to enacting anti-lynching legislation for the first half of the 20th century, and the primary barrier to enacting federal civil rights legislation, and is right now the primary barrier to enacting legislation aimed at protecting our democracy and protecting access to the right to vote, for example. And so I think that the Democrats, if they do have a very good month in November, they're going to have a big decision to make about filibuster reform, because much of what you would want to do, you mentioned that this is a long-standing, there are powerful forces that have been at work for a very long time. And some of what you might want to do, if you are a person who cares about reproductive rights, if you're a person who cares about LGBT rights, and if you're a person who cares about access to the vote and access to democracy, a lot of what you might want to do, you can do by federal statute. Not all of it, but a lot of it. But only, I think it's fair to say, in our present Congress as presently constituted, only if the filibuster is not an obstacle. And whether that means creating exceptions to the filibuster for certain types of legislation, or whether it means doing away with the filibuster altogether, something is going to have to, some portion of that logjam is going to have to be addressed. And I think the other question is, how willing are we to take a serious look at Supreme Court reform? And if we are willing to take a serious look at Supreme Court reform, what kinds of reforms do we want to entertain? And, I'd be happy to talk about this at length. Some of it is kind of technical, but, there's this proposal out there to pass a federal statute that would effectively create term limits in the Supreme Court and cycle justices out of their seats in the Supreme Court and into like other federal court seats if they want to remain on the federal bench. I will admit that I am very skeptical that that is possible. I think if Congress tried to do that, leaving aside the analytical question of whether that should be possible, I think this Supreme Court would say that that's unconstitutional. I think this court would say that that's too much of an intrusion upon their positions and upon their autonomy as a separate branch of the government. Another possibility is to make changes to the jurisdiction of the Supreme Court to try to take certain cases out of their docket altogether, and to say that a lower federal court, like the DC Circuit Court of Appeals, for example, might be the last court that gets to hear certain kinds of cases. I have a lot of concerns about those proposals as well. They strike me as problematic. The proposal that is most clearly constitutionally permissible, that is most clearly in line with earlier reforms that Congress has enacted, and that this Supreme Court could not say boo about, is expanding the Supreme Court and adding, for example, 4 additional justices and having a 13-member Supreme Court, which would both change the balance of power on the Supreme Court if all of those justices were appointed by a President Kamala Harris, if that's the situation we have, but would also, the court has been expanded multiple times during the course of its history. There's simply no question at all about the power of Congress to do this. But that would probably also be the most politically contentious type of reform to enact, right? It would look like a power grab. It would look like, and you'd have to make the case that it's a response to earlier power grabs. And that's a politically and rhetorically complicated case to make, right? The visceral impact of expanding the size of the court, what all of us have lived for our whole lives with a 9-member Supreme Court, would be a different thing qualitatively. But I think it is probably the pathway to Supreme Court reform that, at the very least, is the most clearly constitutionally permissible. And what appetite the Democrats will have for that, if they are in the most favorable possible position, I wouldn't want to speculate.
I'm going to allow Angela Kaysen to talk. She's asked to raise her hand to ask a question. Go ahead, Angela.
Thank you. This goes back to something you just referenced a minute ago about jurisdictional scope. I'm increasingly concerned by the complexity of issues that legal authorities are taking on that are medical and also technological, which they have no capacity to understand the complexities of. And I'm wondering if there is a carve out. Is there any way to simply say these are not within the purview of law? They're social issues. They're not necessarily justice issues. And I'm confused about, or concerned about, when it became the norm for these sort of issues to become jurisdictional. Is that a fair question? Or
sure. Question? And let me start by saying that I mentioned earlier that there are these massive changes in the Supreme Court's jurisprudence over the last few years to the administrative state, and the role of federal agencies and the deference that federal agencies get, right? And what this shift constitutes is a massive power grab by the Supreme Court, because what they are saying is, when Congress enacts a statute, and try as it might, Congress can't provide for every possible contingency in the statute, and it would be pointless to try, right? That's why we have regulations. That's why we have administrative agencies, so that they can take what might be very detailed statutes, but as time unfolds, environmental developments shift, or medical science shifts, and we need agencies that are full of experts who have actual training and actual substantive expertise to say, all right, here's how we need to deal with new threats of particulate matter in the atmosphere, or here's how we need to deal with new, emerging threats to women's reproductive health, or whatever the case may be. And what the Supreme Court has been doing in recent years is taking away the ability of administrative agencies to be authoritative, to make authoritative decisions about how to interpret federal statutes, in relying upon their own expertise in doing so. And the Supreme Court has said, you're not the ones who get to interpret these questions with your expertise. We, the courts, are the ones who have to do so. It's up to us. And the courts don't have the expertise. And I will give an example of this, and it would take me a second to pull this up, and I don't want to sit here awkwardly trying to do this. And so I will ask your forgiveness in advance for not being able to give the details as carefully as I would like to. But there was a decision of the Supreme Court this past term in May or June that related to a regulation of particulate of greenhouse gases. And the greenhouse gas was in question was a gas in the nitrogen oxygen sort of compound family. And there's a specific term of art that is used to describe the family of greenhouse gases that were sought to be regulated. And I think I remember correctly, but I don't want to get it wrong. And so I'll just describe it this way. It's, compounds made of nitrogen and oxygen, right? Primarily of nitrogen and oxygen. And the Supreme Court issued a decision rejecting the expertise of the federal regulators and saying you didn't give us enough evidence and we don't trust your evidence and you didn't do a job and we don't trust your expertise. And they described the gases in question as nitrous oxide, which is laughing gas, right? And they do it over and over and over again in the opinion. It's Justice Gorsuch writing for the court. And the point here is not, well, gotcha, right? You made a mistake and ha, 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 gotcha. And it's laughing gas and it's the perfect thing to use as an example. The point is, if you're an expert, that would jump off the page, right? If you're an expert who actually works on these issues, you know the difference between nitric oxide, I think was the correct term of art. I'm sorry if that's wrong, but I think that was correct. And nitrous oxide. It would probably be a joke in your profession when people make a mistake with this because they're so radically different substances. And so if you actually know what you're talking about, that mistake wouldn't get through to a published opinion because it would be the thing that you would immediately see like a flashing red light. And the fact that this mistake made it through was such a sort of perfect illustration of what it means for judges who don't have the relevant substantive expertise to be the ones making these major decisions and deciding whether the regulators should be deferred to or not. And so I think you're right that it is very, very concerning that courts are arrogating to themselves the power to make these decisions in disregard of the knowledge of the genuine experts, right? The regulators who are actual substantive experts in these fields. And, courts have always played a role in that kind of dispute. So the question that you started with of jurisdiction and could we think of this simply not the kind of thing the courts should decide at all, that would be a big change from how courts have the role that courts have played in disputes like this. But you could have courts offering much greater deference to the experts in a coordinate branch of government, that is to say the federal agencies, who actually know what they're talking about. And I'm sad to say that that is what has been diminishing in recent years. And one of the things that a President Harris and a Democratic Congress might look at, if that's what we have, is trying to enact by federal statute a greater weight and a greater deference to the expertise of the people who actually do this for a living. And that's a little bit beyond my area of expertise, but I know that people are taking that very seriously.
Great. Well, this has been great. Anthea, any wrap-up comments, questions
just to
yourself?
say thank you so much, Tobias. This is great. And, we both could talk about a lot about this for a long time to come, but I hope everybody kind of got a sense of what is at stake for us in this election cycle and where things may be going.
Thank you very much. And let me wrap up with one very, very quick. I want to return, Anthea, to your question about what should people, particularly in, not just in New York and Pennsylvania, as important as those states are, but around the country, what should they be thinking about? And, you and I talked before we got on the webinar today about the state of Florida and Governor Ron DeSantis threatening television stations with criminal prosecution if they run ads in support of the abortion rights provision that is on the ballot in Florida this year. They're literally threatening television stations with criminal prosecution because what they say is the ads are misleading or inaccurate or contain falsehoods, which, by the way, that's untrue. They're not, but leave that aside. And then they bring up this public nuisance statute, which is about making like abating nuisances when you have some kind of toxic sludge coming out of the side of your factory. And they say, well, you're putting bad information out there. That's a nuisance that could cause harm. And so we're telling you take down these ads, or we're going to threaten you with criminal prosecution. I cannot emphasize enough how obviously unconstitutional under the First Amendment this is, right? It's like, it is laughable how unconstitutional it is. But that's the point. The point is, they know that if they actually do this, they're going to lose in court.
Mhm.
They also know that if they make the threat, that might be enough to scare these television stations away from running these ads. And there's not time to go to the courts and remedy the situation in all likelihood before the election, right?
Exactly.
And those kinds of scare tactics are part of what you're seeing when it comes to the trans issue. They're part of what you're seeing certainly when it comes to women's rights issues. And so my sort of last admonition to people as a kind of political matter, as well as, I'm a legal and constitutional expert. I don't know how much of a political expert I am, but when you see people trying to weaponize fear, right, it means they know that they're on the wrong side of the issue. And that fear is the weapon that they have available to them. And that is the time when it is most important to be strong and to be confident that you are on the right side of the issue and that you are not going to give in to people trying to weaponize fear. And if I had one message about how to think about all these big important issues on law and the Constitution that we've been talking about in this election cycle, it's recognize when somebody is trying to weaponize fear and don't let them do it.
Yeah, I could not agree more. Thank you. Thank you
That's great.
so much.
Well, thank you so much, Anthea and Tobias. This has been great. Worrisome, but highly informative and therefore great. That's what we love. Get the information out there as much as we can. Thank you all attendees for joining us and listening in. To the extent you have any questions or follow-up, please send emails to us here at socialsciencesinstitute.org, and we will connect you with the experts directly if you have something relevant that you want to ask them. Also, please join us for the next webinar in the series, which is planned for Saturday, October 26th. Same bad time as this, though, 6 p.m. Eastern Time. And we're going to have Frederick Harris of Columbia University talking with Anthea about polls. Who's right, who's wrong, and why do or don't they matter? And if you're like me, you're as confused by all the polling information we're being shared with, and you would really welcome some expert opinions. So again, thank you, everyone. Thank you again, Anthea and Tobias, and stay safe out there.
Thank you very much.
Thanks.
Thank you.